You see, the question that our friend asks is on point, but we need to put it in context. I'm happy he noted LN 140A. Being the old civil procedure regime. And now we have CI 47. There were a lot of technical formalities in terms of commencing an action. But there has been an effort to simplify matters under CI 47. I'll give you one typical illustration of this observation. Previously, you have to issue a writ without statement of name. So the writ, just like the forum, the title, the parties, and then the nature of the what we call statement of claim. Not the statement of claim as in pleading, but the particular relief which you are looking for. Either declaration of title or recovery of liquidated sum or perpetual injunction, recovery of possession, or whatever. That will be stated in the writ. And then it is said, when it is said, and then under the old law, I think after 8 days or so, you are supposed to now file the statement of what? Claim. But now, we have moved away with simplifying matters. And our simplification is also consistent with reforms going on from where we borrowed our law from. If you go to UK, there's what they call the Lord Wolf reforms. Lord Wolf reforms from 2000 onwards fundamentally or radically changed civil procedure in English law. So when our rules of court are also revising our civil procedure, they will definitely draw inspiration from the reform currents in other jurisdictions. And that is why now it is a law that a writ should be accompanied by a statement of claim. Now, if a writ is not accompanied by a statement of claim, it is a nullity. They must go together. Yeah, so those are some of the things. Now, with respect to the originating summons, originating motion or notice, origination and notice of motion, as we rightly noted, where we don't have previously, the position used to be that where you are not contesting your claim on basis of facts. Where you are not. But then it is more about, let's say, interpretation of the law, or maybe like the application of the law to certain facts. Maybe there's a particular legislation. You want the court to interpret it. You don't need to issue a writ. You can just do originating notice of motion. You do it maybe in the matter of Companies Act 2019 Act 992. In the matter of application by so and so and so for interpretation of Section 6. So you want the court to interpret, and that is the case. You want the court to interpret. So here, it's not about the facts. It's like you want the clear meaning or scope to be what? Be determined. And that is why, to make matters simple, Order 19 at the Rule 2, as we've noted, of CI 47 will say that in any enactment, in any legislation where a person is supposed to make an application, then it should be by originating notice of what? Motion or notice, or just application, as it were. And in all other cases, you have to use a writ. And someone will say that, for me, apart from where a legislation has specifically prescribed that you should use a mode other than writ, it is safe to go by writ. as a writ, you can never go wrong, isn't it? You can never go wrong. But then, where the application has actually insisted that, the enactment has insisted you should go by a particular mode, they don't have a choice. If you don't go by that mode, you'll be told that your process is incompetent, or you've not properly invoked the jurisdiction of the court, as it were. But apart from that, it's safe to go by writ. You're able to very soon be discussing pleadings. You're able to make all allegation of facts, grounding your claim, and then the court will be able to go into it, and that is safe. So let's continue. Otherwise, we'll learn appearance on your own. Yeah, so we want to discuss appearance tonight, having already discussed rates, issue of rates, the venue rules, having already discussed service of rate and other process, having already discussed service out of the jurisdiction under 8. So what is appearance to start with? Yes, once a rate has been issued, we have learned that it must be brought to the attention of the party against whom the rate has been issued. In any case, if you have initiated the proceedings against me in court and I'm not aware of it, so I should be made aware of that. And that is why we discuss service, that I should be served. And we look at the general default that service should be by personal, to serve the person. But then where personal service is not possible, we can do substituted what? Service. But substituted service, you must all go to court to get the leave or permission. You cannot just do it on your own. Personal service, you don't need to go to court, like to get permission first. You and the bailiff will just follow through and then go and serve. But then where you've attempted that 3 or more times and it's not working, you have to go to court and get the permission and explain to the court why it is proper for you to be allowed to use substituted means of what? Of service. So let's keep that in mind. So you are aware that you have been sealed. You have to enter appearance. You have to enter appearance. So appearance is the formal act by which a defendant signifies to the court and the plaintiff that the rate has been received and that the defendant intends to respond to the action. So simply by entry of appearance is a document or a process you file. And by that process, you are telling the court that, yes, I'm aware that some proceedings have been initiated against me, and I am ready to respond or deal with it. If I need to be served, my address is indicated. This is how I may be reached. That is what appearance is supposed to be. So, therefore, appearance performs, if you like, 3 critical functions. 1, it is an acknowledgement of service of the rate. You acknowledge that the rate has been served on you. 2, it determines whether the defendant submits to the jurisdiction of the court or challenges it. Whether the defendant submits to the jurisdiction of the court or challenges it. You know, when we talk about jurisdiction, there are various facets of jurisdiction. And one important facet is what we call personal jurisdiction. Personal jurisdiction means that the particular party is amenable to the exercise of the court of its power over him. And that is why service is what? Is important. So when you are served and then you acknowledge it. You are not only acknowledging that, yes, I've received the writ. If you just did, later we are going to talk about the called unconditional appearance, or when say appearance without qualifying it, it means unconditional appearance. Where it is not unconditional, qualified by saying a conditional appearance. And particularly so, where it is unconditional appearance, you are saying that you submit to the jurisdiction of the court. Or, but if it's conditional, you're saying that you challenge it. You are challenging the jurisdiction of the court, as the case may be. And 3, it regulates the defendant's exposure to default judgment. It regulates the defendant's exposure to default judgment. When we say default judgment, very soon when we are discussing pleadings, we told that if you look at the rate itself, the rates, if you remember, when we look at the samples, there's a statement there that within how many days, if you don't enter appearance, yes, we entered against within default. So if the rate itself, it's giving you a warning that you must enter appearance. If you don't, after the statutory period, the statutory period is what? 8 days. The party who initiated the process can go and get judgment entered against you for defaulting to enter appearance. And as we know, Order 9 governs appearance, and Order 10 governs consequences for defaulting in entering appearance. If you don't enter appearance, what the consequences will be, Order 10 will tell us. We will be looking at the two together. Yes. The third point, I said that it regulates the defendant's exposure to default judgment. In other words, appearance is one way of helping us to find out whether the defendant can have a judgment in default of appearance against him. That is all we're trying to say. So if we look at Order 9, our reader is there, isn't it? Okay. So Order 9, Rule 1. Will you read it for us? Sorry. You want to? Oh, that's what she's saying. Okay, so let's hear you.
Subject to complying with one of these duties, a defendant to an action may whether or not the defendant dispute if as not capacity or assertions then as not decided, or any other action, power guarantee the action and defendant requested or by law.
Good. So, simply put, where you have been sued, either in your personal capacity or representative capacity, or maybe like a body corporate, you need to enter what? Appearance. You need to enter appearance. And the appearance is supposed to also have a certain information. So let's look at the Order 9, Rule 1, 2.
Stop stated conflict appearance, whether and then defense in person or by the lawyer, and whether this is stated on the rates or not.
Okay, good. Now, let us note that appearance is not filed by only a lawyer. If you don't have a lawyer, you just file it by yourself. If you have a lawyer, the lawyer will say that the defendant is entering the, I think that I gave some samples to,
Yes.
yeah, so if you look at the samples with those online, I think you can see it on the, good, okay, let me show one. I don't know that you see what I'm showing, you see it. So if we look at it, for example, notice of appearance, please take notice that the first defendant have this day, acting by their solicitor, so entered appearance, and that address for service is as follows, as the case what may be. So that is what is required. The address is very important. And the reason for the address is that the plaintiff might have just said that plaintiff shall direct service, as we noted from the earlier discussion, where the plaintiff does not show up the address of the defendant. So therefore, if it's served on you and you acknowledge that you are the defendant referred to by the process, and you are entering appearance, you need to indicate your address. And that is why the rule says that your residential and then occupational what address shall be stated on the appearance, on the entry of appearance. Now let's look at the 9.3. But here you notice that if you look at the sample I gave you, where a lawyer is doing the entry of appearance, we don't actually use the address of the defendant, the actual residential address of the defendant, because the lawyer is the one representing. So the lawyer rather provide the address, in this case the occupational what? Address, what you can serve the lawyer. Let's look at the 9.13.
On the embarrassed law, they have acted as force on notice to accompany the defendants to and the constable shall be more by the defendant. And what the defendant fails to comply with the court's orders, be what the related time. The defendant shall be considered to not manfully under appearance.
Good. So it is a requirement that your address, residential or occupational, should be stated on the entry of appearance, that document. But let's suppose that you filed the appearance, but you've omitted those addresses. The plaintiff has an election, and that is why under 9 Rule 1.3, pay attention, it didn't say the plaintiff shall apply. It said that the plaintiff may. Look at your law. It said that where there's a default, the plaintiff may apply to the court on notice. Did you see that? Meaning that if the omission is there, it's not fatal, but then you will decide whether you want to waive your right or you want to indulge or you want to take it up. And that is why the example I gave you, like the lawyer entering appearance on behalf of the defendant. We just saw the lawyer's address and not that of the defendant. If you are a troublesome litigant, you can come under Order 9, Rule 1.3 and says that, but the law says that your residential address should also be what? Stated. So in addition to your lawyer's address, I also want to see your own address. In any case, if I get judgment against you, or if a cost is awarded against you, so that it becomes easier for me to do what? To enforce it. Because if it comes to enforcement of judgments or orders or costs, you don't serve the entry of course or the entry of judgment on the lawyer. You have to serve it personally on the person. If you the person granted by a lawyer, you have to serve it on the party himself. Because not the lawyer is going to pay the money. It's a party, isn't it? And that is why, but as I said, that's why the law says that may. So that if you decide not to challenge it, then that it can go. But then if you want to take it up, if you take it up, the court will order the person to do it. If the person does not do it, you are considered as not having entered appearance. So therefore, you are no different from someone who defaulted in entering appearance. And whatever the consequences for defaulting entering appearance will apply to you as the case may be. So let's look at the method of filing appearance.
Parents file by giving a notice for appearance in Chile in compliance with Rule 3 of this board. And mandating all similar parents to the registry together with two staff members, one suggested an excess lawyer, or two of them, the acting person, and business address or service, and the other address the defendant by the appearance.
Good. If we read the Rule 3, for example, we notice that the rules of court committee have provided a template. Maybe to use a modern computer language, a template, but we call like form. Like so, form 5. So if you just jump to page 279 of your rules, I don't know if there are 279, my version is 279. There are 279. And if you're using the approved version, you are not using your own unapproved version. Form 5, notice of appearance. Okay, good. So let's look at the form, like the format or the template. So if it's the High Court, then you cross out the Circuit Court. If it's the Circuit Court, you cross out the High Court. If you look at it, it will always bear, please let's remember, it will always bear the title, the court, the venue, the particular court. So in the High Court of Justice, let's say Accra or Kumasi, as the case may be. And then we have the title of the case. That is the parties will also come after that. And then after the parties, we have the statement signifying the invented appearance. Take notice that the defendant hereby enters appearance to the plaintiff's writ, and that is address for service as follows. So you provide the address for what? For service. And here, if it is a lawyer doing it, they'll use Form 5A. Go to the next page. If it's a lawyer entering the appearance, we use Form 5A. The same format, just like modification. So the title, the forum, that is a venue, then the title, the parties. Then take notice that the defendant hereby enters appearance by his lawyer. So that is the modification. By his lawyer, whose address for services as follows. And I have to state the number and date of the lawyer's current board license. You know, there's a case about the Tariwaja, Justin Tariwaja, where the court decided to crack the whip. Of course, it has always been the law and the Legal Profession Act of 1960 and 32 that you must be licensed and you must also be attached or associated with a licensed law firm. You practice law in what? In Ghana. That has been the law. 2003, when I became a lawyer, the law was there. 1971, when people became lawyers, the law was there. But you know, Ghana, for a long time, things were relaxed. The law is there, but no one really enforce it, as somebody will say, giddy giddy, isn't it? Strictly. But the law is not the case that it is a new law. No, it's not a new law. It has been there since Kwame Nkrumah's days. But there was some kind of a laxity in enforcement. But then, in Tariwaja coming, the court became interested in saying that if the law says that you must have you must be licensed, then that's what it says. You are either licensed or you are not what? You are not licensed. If you are not licensed, you cannot be a lawyer for another person. It doesn't mean that the party cannot conduct the case, but you cannot conduct it for the person. And that is why if you look at the Form A, for example, you notice that we have the number and date of the lawyer's current what? License. So if you are a lawyer for a party, you could, for example, conduct a quick check. And the Ghana Bar Association, they've done well. At least I remember, as at the time I was in practice, they have the portal. I'm sure it's really become better now, where you can just enter the portal and verify whether someone is a lawyer in the person's chambers and place, whether the person is based in Accra, Kumasi, Tamale, or wherever. You can check it. So when you check and you don't find it, then there's a red flag. Either the person has not paid is not in good standing. He's not paid, he's not licensed. And that can give you some weapon for you to harass the person. Then you file the motion to try and set aside whatever he has done, as it were.
Hello.
Then, if yes.
As I observed the form that you sent for the document, you did not cite the order here, notice of appearance.
Yes.
So I just want to know whether it is not so important
Good.
whether to cite or not to cite.
It's important, but if it's absent, it's not fatal. So if you look at that's when he was, that's what it's called as it was. And in the case, we started the mouthful. The mouthful. There was this issue as to whether you file a motion and you don't state the rule under which the motion is brought. Does it render the motion competent or not? And then he, writing for the Supreme Court, said that it's good practice. It will help the court if it is written, but then if it is omitted, it doesn't render it what a nullity or fatal, as it were. Yeah. So it's good. It will be there. But then if, for example, someone has filed appearance and he has not written that, I'll be taking, because from the record of appeals I'm working on, if I get, I'll be taking pictures of a lot of these processes and just pushing them to so that we see different ways of doing it. But you don't go to court and say that because you didn't state on that 9 on the entry of appearance, so it should be said both side.
No.
Yes.
So with regards to the issue of the residential and the business address,
yes.
You look at item A, that's the instance where the business is being represented by lawyer.
Yeah.
You realize that the address in terms of the business and residential requirement is that of the lawyer.
Yes.
But if you just put that the rules, that's specifically for the 901 sub 2.
Yes.
And it says that the residential and occupational address of the defendant shall be stated on the appearance whether the defendant's defense is blessing or by lawyer. So if I understand the sub 2, it indicates that even if you are listening for 5A, then the address that is supposed to be provided should be the defendant's address in terms of residential business. Right now, you realize that from 5A, it's not that the lawyer's details that are provided over it. So let's go to check if apart from the lawyer's address in terms of residential business, you should also provide that of the defendant.
Okay, so good. To answer that, let's look at the order 9-3. The contents. No, the contents. The one we finish. Then it becomes a matter of interpretation. Then there's rule of interpretation that you must read the document as a whole. So let's look at order 9-3. Then we'll answer our friend's question.
Those three contents of notice. The notice of appearance shall profile the schedule, which shall specify the service, which shall be paid. The defendant is a resident, SR, or if the defendant has no facial residence. The address of the place in this country, or to which documents the defendant is generated or sent, and to be what the defendant has by a lawyer. The address of that lawyer in this country.
Good. So if you look at the bill at the 3, no, it uses the conjunctive instead of disjunction, isn't it? It says and. So one, we say that the intent of that group is that even if you have like a lawyer, you must still have your residential address and occupational address, as the case may be. And I think that is the proper thing. And if we take note of the fact that the address is not only meant to let you be served, but more importantly, if judgment is obtained against you, if costs are ordered against you, and want to enforce it, we should be able to know where you are to look for your property and sell. So and that is why the address becomes crucial. And that is why the rule rightly says that if it's omitted, you can go to court and get the court to compel the person to disclose it. And the court so orders that the person does not. Then his appearance will be treated as not a valid appearance and is not an appearance. But then you are right. You can also ignore it and say that, well, I want my case to go fast. I see. And why do I have to delay it? So you are right. It's said.
Yeah, access that a defendant is going to delay it.
Yes. Yeah, so if you get like a stubborn defendant, you'll be doing things in a haphazard way, knowing that you come and complain. Then as you complain to, he's buying more time. Just like if you are trying to look for possession against a certain tenant, he is not interested in the case going fast. The longer the case drags, it remains. Yeah. So you are right. It ought to be there. But then you, the plaintiff, you will decide whether you compel. But if I am a litigant, I will always compel that, especially so if I don't know the actual location of the defendant, so that when it comes to enforcement, you don't struggle. But one point we have to notice that a company cannot act in person. It's mandatory must a company be always represented by a lawyer. When you are still as an individual, you don't need to go for a lawyer if you don't want one. But if you're a company and a company is sued, the company cannot just enter appearance on its own. It must do so by what? Through a lawyer. Yeah, so that is very important. I want us to look at the order 934 in trying to answer our friend's question again. Yes. Order 9-3, sub-rule 4.
It's satisfied on abundantly that any address specified in the notice of appearance is not genuine. The court is set aside everyone.
Good. So we do not want fake address. So if appearances, and of course, lawyers, we often don't look in our eyes, we take it for granted. But then as we begin to look at the rules closely, you get to know that there are a lot of things that we can do. But usually when we get appearance, we don't pay so much attention to the content, but we have to pay attention. If you have suspicion that this address is not a genuine address, especially the residential address or the occupational address, maybe take trouble to follow it if you can locate the property or use the Ghana Post app and so on, and it doesn't work. We can go to court and bring it to the attention of the court in terms of Order 934 that the address specified in the notice of appearance is not genuine. And the court will look at it. The court is satisfied that it is not genuine. The court will set aside the appearance. So when the appearance is set aside, time is still running. We are going to look at Rule 5, the time limit for appearance, which is 8 days. So if you enter the appearance, but then for whatever reason it's set aside, like maybe you haven't provided the fake address, time will not stop because the address you brought was said to be wrong. No, time is running. So if the 8 days is gone, it's gone. The plaintiff could, for example, take the necessary actions against you. So let's keep note of that. So let's look at the 9.4. Yes. Yes, please.
Thank you. Is out as under Order 4, it's another 401. The partners who can take trigger proceedings at the court. And it says that a body operates must be represented by a lawyer.
Yes.
And provide an exception in a case where an enhancement is expressed issue occurs.
Provide exception where
an enhancement expressed.
Yeah, absolutely. Yeah.
So the same way I'm trying to just suppose that there are errors. And as you mentioned, that it has to be the lawyer. So I want to find out whether that's
who apply. Good. If even what the Order 4 Rule 1 said, that a company must sue by a lawyer unless an enactment has provided otherwise. Even if that statement is not part of Order 4, and you have another enactment which has said that a company can sue without a lawyer, it will still be effective. Mind you, CI 47 is a subsidiary legislation. It's a subsidiary legislation, not the parent legislation. It's a rules of court. It's law all right, but in terms of the hierarchy of legal norms, it may be inferior to a major act of God for Parliament. So in the same vein, if there's any legislation which says that a company can enter appearance by itself, as it were, that will be it. But conceptually, for companies, it become difficult. The reason being that the company is an official person, isn't it? So if we say by itself, it will definitely be by a director or a secretary. And so that is the difficulty. And that is why it becomes simple if it's represented by a lawyer. Now let's look at time limited for entering appearance. Order 9, Rule 5. But just to be sure, because we are reading the rules, let's be systematic. I said the rule 4, procedure on the receipt of notice. So when you have filed the notice of appearance, the registrar will have to stamp it. It's very important. If you want to find out when you entered appearance, it's not the date you printed it in your office which matters. Usually when we do process, we do dated on 18th December 2025 at Accra, Instruct Chambers or whatever. That date is not the most important date in determining when you entered appearance. The most important date is the stamp which the registrar put. Then he will indicate the date and the time which you entered the appearance. And there's what you call a course book. A course book, like a big book, the registrars that they know, in which the entries will be made that you entered appearance this day at this time. So let's look at the time limited for entering appearance, rule 5. The mic is.
Thank you. In these rules, references to the time for appearance are references. A. In the case of the writ served in the township, to 8 days after the service of the writ, or when the time has been extended by the court. Within that time, action to get letter. In the case of notice of the writ served outside the township, to the time limited by order of the court, under Rule 7, Rule 13, Section 2, or what it reads, Rule 4, or what the time has been extended to the extended time.
Good. So the general rule is that where a writ has been served on you in Ghana, you must enter appearance within 8 days. That is a general rule. It is permissible for you to go to court for extension of time within which to file appearance. If you look at order 80 on time, have you looked at order 80 before? Order 80 time. Look at order 80 rule 4. Order 80 rule 4.
80 Rule 4, extension or reduction of time. The court may, on substitutes, just by order, extend or reduce the period within which a person is required or authorized by reason or by any judgment, order or direction to do any act in any cause or manner.
2. What?
Court may extend its session, although the application for extension is not made until after the expiration of the period.
Good. So, in terms of order 80 to 4, it is permissible for the court to extend the period for filing anything, including appearance. But not until that is done, then you must comply with the 8 days. So that is the first thing that we have to notice. And where the writ has been issued, but notice of it is to be served outside the jurisdiction, as you saw under the 7 and the 8 read together. Usually, the court will prescribe the mode of service and then the timeline, just as when you have substituted service. When the court makes an order for substituted service, the court will prescribe the duration within which the service is to remain in place. After which time the person will be considered as having been served, so that if he doesn't do the needful, then time will run against him. Maybe sometimes the court will say, okay, let the rates and the status of claim be posted on the presidential number plot 1, 2, so and so. Posting to remain for 21 days, or 14 days, or 20 days, as the court may determine. So where that has been prescribed, the time for entering appearance will be the time prescribed by the court. So the court said that posting to remain for 20 days. So when it is posted on the working day, you have 20 days within which to do what? To enter appearance. If after expiry of the period you haven't entered, then you defaulted, then the necessary steps may be taken by the other party. Yes.
So apart from this, circumstance under what? Sorry. So apart from this exception,
Yes.
circumstance the court extend the dates for the
Appearance. Oh, good. So there's what we call the late appearance. Okay, we're going to talk about late appearance, where the sanctioned period is over, and you still want to enter appearance. You want to come into the case. You go to court, and then you explain to the court why you've not been able to comply. The sentence can be two ways. Either the time has not really elapsed, but for some reasons, you don't want to rush to enter appearance. So you need a bit more time, maybe you're doing certain checks and so on. So sometimes you even have to decide whether you're going to do conditional appearance or conditional appearance. We're going to talk about that. And depending upon what information you're looking for, you may need time to be sending. Or the time has actually elapsed. And on the 80 report says that when the time has actually expired, you can still go forward. Essentially, isn't it? Good.
Yes, with this, when you are going for the extension, you actually notify the other side that you are going for it. And you object to going for the extension, knowing very well that it could be one of the tactics that you are employing to actually be the vote.
Well, thank you. In terms of identity, every application will be on notice, except when the rules of the permit that should be expired, or you make a case to the court that the court should allow you to be involved expired. For example, if you look at order 25, when it comes to interim reduction, the limited interim reduction for the up to 10 days, it's always by expired. After 10 days, then you repeat it on notice. So in this particular instance from your question, you are the defendant, there's a plaintiff. So why do you, it's in your interest to go on notice to the plaintiff, so that the plaintiff is aware that the court is giving you more time. Otherwise, the plaintiff may even file a motion for judgment in default of what? Appearance. But then the plaintiff is alone, then the plaintiff has not need to go through that before the plaintiff will go that, oh, but this person has come for leave already. So it's better to always go on notice. Except where by, for example, substituted service. Conceptually, you cannot go on notice. If you go on notice, then there's no basis for you asking for the substituted service, isn't it? Because say you cannot send the person, that's not what they go to online. So, for example, so examination, if I see that, I will say that this student is not ready to set my examining question to the student. The person should be given more time to do what. No, but you tell me. No, let's be fair. These are not ratings. These are elementary aspects of the civil procedure identity. So it means the simple things, you haven't appreciated it. how can you be sure that when you are dealing with enforcement of judgment, guarantee and to other things, you'll be able to appreciate this? It's not fair.
We learn on the field.
You learn on the field. Yeah, so yes.
The second part of the question is whether they can object. So
Please use the mic.
the second part of the question is whether the Adams agree with the applicant or the applicant can object to the person or asking to
Oh, absolutely. Any application which is on notice is amenable to challenge. And that is why we have affidavit in what? Position. And in fact, if I am presiding and application is brought and you don't oppose it, unless you are raising the legal point, otherwise I'll not award costs because you haven't done anything, isn't it? Yeah, so long as it's on notice, you can challenge. But this type of thing, if you are challenging, sometimes it's not everything you need to challenge. If you look at the thing and you think that this is so innocuous and it's genuine, why do you challenge for challenging sake, isn't it?
But sometimes it's for malice. You just want to look at it.
Okay. Yeah, so it is. Let's look at the rules, 9 rules. But please, just in case you have forgotten, where a writ is issued, a notice going to serve outside Ghana, the order allowing it to be issued will always prescribe, let's say, that the time for entering or appearance. So don't let us forget that. And I hope if you are given a question, you'll be able to do it. Maybe you are told the story. And when it comes to issue of a writ, notice of wages to serve outside the jurisdiction, you have to know the procedure. Two-stage procedure. The first stage or the first aspect is for you to go to court, isn't it? By ex parte what? Motion. Ex parte originating application. Because you are starting the matter. So you go, you have the individual courts, the forum, the prospective parties, and then you have the matter of application for leave. So the time will be the matter of application for what? For leave. To have a rate issue, service of which would be, a notice of which would be served outside the jurisdiction. Then you have your affidavit. So the affidavit, you talk about the fact that you have this particular person, you have this claim on this, and the person is based outside what? Ghana. And then you advise, as very recently through that, the rate cannot be just said. It is only a notice of which you can serve on it, and the leave can be obtained from court. And we think that after referring to circumstances of this case, it is a good case. Even the court should assign this to grant the leave. If attached to the affidavit, an exhibit, which is the proposed Writ of Summons statement of claim. So the proposed Writ of Summons statement of claim will have to be exhibited. So when the court reads it, the court hears whether the court is satisfied. And don't forget that under 8, we have conditions under which leave may be granted or may not be granted in respect of a rate which already serve outside the limitation. Remember that. Sorry. No, that one is a subpoena service. But this one, the what is it? Order 8 through 3. You know, if you go to route 3 cases where leave may be granted, you know they have a list, and so you have to your affidavit will have to bring 1 or 2. I mean, 1 is enough, like as a basis for convincing the court that yes, you've met the requirements of the law, like having regard to the court should to grant what the leave. Now, when the leave has been granted, the court will, and of course, in application, you also have to suggest the move. If you are going to do courier, I ask you to read. If you are going to do courier like DHL or something like that, remember. Or if you are going to get them sent through the Ministry of Foreign Affairs, if you look at order 8, 8, do you remember? Or order 8 through 6, we have what we call the Civil Procedural Convention. Some countries, we have agreement with them. So when you get it, that country through the Foreign Affairs, and then the Ghana diplomatic mission there, they can wheel it into their local system for it to be said as if the process that we issued from there. But that one is possible for its country that we have that Civil Procedure Convention with. But if we don't have, you can still get a court to do it through courier, DHL, and Federal Express, and so on. Yes.
So, if they don't have, if there is no convention in that particular,
yes, there's no agreement.
There's no agreement.
Yes.
Can you also like give the the convention and then serve that process? So you see the convention will tell you that if there is a court or an authority, right, you should pass through the authority before you can serve the. So let's say this is the case where there is no conventions as such, but if you want to still go to the court system of that particular.
No, you have to go through. So let's look at the order 8 says. Says 1 talks about where the convention applies, and then says 2 talks about where there's no convention. So let's go back briefly because of your question. Of course, all of you are supposed to have finished reading that based on the assignment I gave you. If you look at order 8 says, whereby these rules, notice of a writ is to be served on the defendant in a country with respect to which there exists a civil procedural convention that provides for service in that country of process of the court. In this one, I refer to as a convention. The notice may be served A, through the judicial authorities of that country, or B, through a Ghana consul in that country, subject to any provision of a convention as to the nationality of person who may be so served. So that is where, under the Civil Procedure Convention, we have an agreement, or we have a party, a country which is a party to that convention. In that case, once the order is given and is routed through Ghana's embassy or Ghana High Commission, they will just relay it to their judicial service or just the court system, and their bailiff or whatever process they have, like serving a normal process as if it had been initiated there, will be done. Then, where there is no we don't have like the convention does not apply, or the particular country where the person is based is not in a convention country, the civil convention yes. Then Rule 8 says to apply, who says that, quote, whereby these rules, notice of a writ is to be served on a defendant in a country with respect to which a convention does not exist. That's the procedural convention. Does not exist. The notice may be served, A, through the government of that country where that government is willing to effect service. So that one is not mandatory. It's a discretion of the particular country. If we are just friends with that country and they said, okay, we are amenable to help you to serve it on this person who is there. It's different from extradition. Extradition usually has to do with the criminal matters. But here we are talking about civil procedure. So let's assume that this Kenuforiata case, for example, let's assume it's not a criminal case. Let's assume it's not a criminal case and it's a civil case. And let's assume that US is not the Civil Procedure Convention. But then the US government said that, if a writ has been issued here against him, a notice needs to be served on him. Yeah, we are very happy to help you to serve it on him. So give it to us, we'll give it to the bailiffs in the US judicial system to go and serve it on what? On him. But as I said, we are talking about civil cases. We are not talking about criminal procedure. Criminal procedure will have to do with the extradition. That is a different matter altogether. Or where the government is not willing to just help, there's another solution. That is 862B, or through a Ghana consul in that country, except where service through such an authority is contrary to the laws of that country. So, if the laws of that country do not forbid a diplomatic mission from serving a judicial process from overseas on someone within that territory, then the Ghana mission there can use their officers to get the same, as it were. But it is also possible for you to go by airmail. So let's look at Order 8 to 11. Order 8 to 11. So if we look at Order 8 to 11, we are told, if you look at the heading, service by mail, the court, in granting leave to serve a document out of the jurisdiction under this order, may, in an appropriate case, direct that airmail shall be used by the party effecting the service. So where you want to avoid all the complexities of Ghana mission, the government being willing to, the government of that country being willing to effect the service, just convince the court that DHL, you have an address which you have probably tested online. The address is genuine. You print it. You convince the court that this address is good, so that if it will send it, it will get to the person. The court may just give you a simple order. Do a registered courier, as it were. So that one will bring all this wahala of Civil Procedure Convention, the government of that country willing to serve you, bring all those to an end and become very simple. Yeah, so let's come back to our discussion. We're looking at late appearance. Let's look at the Order 9 recess. Order 9 recess, yes.
We have found that the judgment has been executed. The action is set for the of the court. Except as provided by 5:1, then these rules shall be construed as precluding a defendant from filing appearance after the time for appearance. And if the defendant has known, the defendant shall not, unless the court otherwise orders, be entitled to serve documents on duty and attend later than if the defendant has appeared to be heard.
Good. So, Order 9 recess is talking about late appearance. Any appearance after the 8 days is what? It's late appearance. And again, judgment might have been entered. And once judgment has been entered, you can still file appearance, but you must get leave of the court. If judgment has been entered and you want to come maybe have to set aside or anything like that, you must come in first. So you must get the leave of the court. You enter late appearance, and then the court will give you leave maybe to file defense, or you apply to have a judgment set aside, assuming a judgment has been entered. If a judgment has been entered, you need to clear it. If the judgment is not cleared, what is the use of your defense? But the judgment has brought some kind of finality to the controversy. But if you think that you are not given the opportunity to answer to whatever claim that was brought, so you want the opportunity, the judgment should be clear. Then we are back to the litigation or the normal controversy state, so that you are allowed to also file your defense, as it were, and then the matter can actually progress. So let us take note of that. So what we gather from Order 9 Rule 6 is that where a defendant has been late, that it has defaulted in filing appearance within the statutory 8 days, and supposing the plaintiff has exercised his right to go to court by ex parte application to look for judgment in default of what? Appearance. That the judgment in default appearance is actually given. And we are going to talk more about that under 10. It will notice of that judgment will have to be served on the defendant. So when you are there and they come and serve the default judgment on you, that will make you aware that judgment has been entered against you. So you want to go to court to have the judgment set what? Aside. And then you are given leave, to enter appearance, to file defense, and so on. But mind you, where you apply for judgment to set aside, you will not be given leave. So when there's a judgment default of appearance, you have to think of two things. The judgment default appearance must be set aside. At the same time, you must ask the court for what? For leave to enter appearance. Late appearance, yes. The civil procedure is really coming up. Yes.
So do you do that at the same time?
Like one and the same. Yes, one here. It is permissible in one motion. You're asking for more than one thing. It's permissible. Except that when it comes to court of appeal, we hate the situation where, let's say that under 20 of the CIDT, I'm not going to say 47, court of appeal rules. When civil form 6 has been served on you, that is the record of appeal transmitted from the High Court to the Court of Appeal, you are supposed to file the written submissions. You have 1 days to do that. After expiration of 21 days, the registrar will certify that fact to the court, so that the court will strike or dismiss your appeal for non-compliance. So that is that. Become aware, and you bring a motion that the court should restore your appeal. And you see lawyers also asking for leave to file their written submission out of work. Right? We don't like that. The appeal is out. Let the appeal reinstated. When the appeal is reinstated, then you come again to look for the extension of time of relief to file the written of submission. Yes. It includes. Okay, I take you back to order 80. Order 80 is on time. So anytime you are not sure of what the time reckoning is, please go back to order what? 80. Order 80. Yes, so let's start from order 80 rule 1. Any period of time faced by these rules or by any judgment and so on for doing any act shall be reckoned in accordance with this rule. So if you want to know how to count the 8 days or whatever days, we have to be guided by order 80. Order 80 1, 2, where the act is required to be done within a specified period, after or from a specified date, the period begins to run immediately after that date. Let's look at rule 3. Where the act is required to be done within or no later than a specified period, before a specified date, the period ends immediately before that date. Now for your question, 4 and 5, where the act is required to be done a specified number of clear days before or after a specified day, at least that number of days shall intervene between the day on which that is done and that day. So let's say that when it comes to motion, order 19 rule 20, that there should be at least how many clear days? How many clear days? 3 what? Clear days. So 3 clear days means 3 clear days. It means that there should be, it's filed today, you have 3 between the filing and the date that the matter will come before the court, isn't it? So that is what order 80 rule 1 4 is telling us. Then let's look at the order 80 rule 1 5. Where apart from this rule, the period in question is a period of 7 days. Our friend, it's a period of 7 days or less, and would include a Saturday, Sunday, or a public holiday. That day shall be what? Excluded. But the catch is that it must be 7 days or less, isn't it? If it's 7 days or less, then the weekend and the public holidays are what? Excluded. What it means is that if it is more than 7 days, then they are included, isn't it? But we haven't finished. Let's look at the order 80 rule 2 and rule 3. Unless the court otherwise directs, the times of the vacations in any year shall be excluded in reckoning any period prescribed by any enactment, these rules, or by any order or direction for serving, filing, or amending a pleading. Yeah, so the general rule is that time, as a general rule, time does not run for filing pleadings within vacation. Then 83 non-working days, where the time prescribed by these rules or by any judgment, order, or direction for doing any act at an office of the court expires on a day on which that office is closed. And for that reason, that act cannot be done on that day. The act shall be in time if done on the next day on which that office is open. So let's say that You're supposed to enter appearance. Let's assume you were served on you probably served on the Thursday, 8 days. One with the 8th day, and if assuming it's Thursday, you are served the rate of Thursday. Next Thursday. No. So let's assume that that Thursday was a promise of it like a Muslim's holiday or some Christian holiday, as the case would be. The registry will close, isn't it?
Yeah.
According to the 80, Friday, if you get the file, you have complied with the 8 days. Because when the 8th day became due, the office was closed. So it was not your fault, isn't it? So let's come back to what we were discussing. Let's look at types of appearance quickly. We have 2 types of appearance. We have conditional and unconditional what? Appearance. And Order 9, Rule 7 actually governs that. So can you take that for us?
A defendant may file a conditional appearance. A conditional 2, a conditional 4, that the person sued the partner of a friend in the name of that one and served the partner is to be treated for all purposes. Conditional appearance. Unless the defendant applies to the court to legally find evidence for the purpose. For an order under the 8 and the court makes an order but
Good. So, conditional appearance and unconditional appearance, what are they? Unconditional appearance is entered where the defendant has no objection to the validity of the writ. Unconditional, where the defendant has no objection or no challenge to the validity of the writ, the service of the writ, or the jurisdiction of the court. Where you are cool, you are satisfied that there's no problem with the formal validity of the rate, like the requirements as we've learned already, or you have no problem with the service. You think that the service of the rate on you is quite proper. And again, you think that the jurisdiction of the court has jurisdiction and is properly invoked. Where that is the case, you enter unconditional what? Appearance. So by entering unconditional appearance, the defendant submits to the jurisdiction of the court. So there's a very old case, Edusei against the Dinners Club Swiss, SA, and 1982-83 to GLL 809. The court held entirely that an unconditional appearance is a waiver of any complaint regarding irregularity in the issuance or service of the rates. In other words, where you've made unconditional appearance, then you have waived or you have overlooked any defects in the issue of the rate and also the service of what? Of the rate. Yes. Okay. I think the Edusei against the Dinners or Diners Club Swiss, SUISSE, then SA 1982-83 to JLL 809. Well, it is also said that an unconditional appearance is treated as a fresh procedural step, which disentitles the defendant from subsequently complaining about defects in the service or issuance of the rates. It's the same point we have said already, just putting it in another way. Remember the 81. Irregularities, non-compliance, remember?
Yes.
And one of the things we learned under the 81 is that where a party has committed non-compliance, like what the rule says should be done, and you are aware, you are supposed to, if you want to take it up, you are supposed to complain, either to have a set aside or whatever the case may be, at the earliest opportunity. That is when you become aware. Now, when you become aware and you don't take it up, but you continue to conduct the case, you take a fresh step upon becoming aware, then you are deemed to have waived your right of what? Of complaining about the irregularity. And you cannot take it up again. So that is the point being made. For that matter, in Kwaiko, Uaiko, against the Mobile Oil Ghana Limited. Mobile Oil Ghana Limited, 1977, 1 JLI 461. I mean, the court made the point that a defendant wishing to take objection to an irregularity in the issuance of a writ has to enter conditional appearance and not unconditional what? Appearance. But we must say that there are certain matters, whether you enter conditional or conditional appearance. If the court does not have jurisdiction, can be raised on appeal. So that is what we're talking about. For matters of jurisdiction, it doesn't matter that you have waived it. What about conditional appearance? We have seen Order 9, Rule 7, that a conditional appearance, also known as appearance under protest. Appearance under what? Protest. Is entered where the defendant disputes the issuance of the writ, the service of the writ, or notice of the writ, or the jurisdiction of the court. So the conditional appearance will enable the defendant, without submitting to the jurisdiction of the court, to come in and raise whatever challenge he has to certain foundational defects, certain basic defects, either in the writ or in the service of what? Of the writ. There's a case we need to look at is the Republic as in High Court Accra, S Party Aite. S Party Aite 2003-2004, 1 SCJLR 398. And in that case, Justice Pega, speaking for the Supreme Court, identify the following grounds as justifying conditional appearance. Just what we've been talking about is not anything different. Non-compliance with the rules of issuance of a writ or notice of a writ, non-compliance with the rules of service of writ, and then lack of jurisdiction of the court. Now, where you have entered conditional appearance, they're about to call a mandatory follow-up. So mandatory follow-up application under Order 9 Rule 8. Order 9 Rule 8. Yes, please, let's take it. Order 9 Rule 8. The mandatory follow-up application after entering conditional appearance under Order 9 Rule 7. Yes, Rule 8.
A defendant may act for final appearance, or if a defendant has filed a conditional appearance within 14 days after final appearance, write to the court for an order to A, set aside the writ or service of the writ. B, declare declare that the writ of acknowledgement has not been served by the defendant. Or C, discharge any order that gives leave to serve by notice on the defendants outside the country.
Good. Yeah, so if you have entered conditional appearance, then within a period of 14 days from the filing of the appearance, you are supposed to go to court by application. And of course, such an application will be ex parte or notice. Ex parte or notice. Why notice and not ex parte? Those who said notice. You are making application number 9 through what? Through 8. Should it be ex parte or notice? Why? Yes, wait. Why or notice? Yes. Somebody has caused his retribution and he has caused it to be served on you. You want the court to throw away the whole writ or to say that it will be served on you. And you don't want the person to come and listen to what you are saying, so that he too may tell the court what needs to be told the court. So naturally, cannot be what? That's what. And so, as you say, either you want the writ to be set aside or the service of the writ to be set aside. Because if you don't get, assuming you have a problem with the service of the writ, maybe it's not properly done, and you don't move for it to be set aside, the subsequent steps will be taken. And when the subsequent steps are taken, the action may be progressing to deadly and other orders will be made against you. But if you had actually moved time yourself, get the service set aside, you have arrested further progress of the process. Well, if you fail to file the application within 14 days, the unconditional appearance will automatically become, so the conditional appearance will become automatically unconditional appearance. But some lawyers think that if I want more time to file my civil defense, I will file conditional appearance so that the 14 days will probably not be running. But that is wrong. Because if you don't bring the application within 14 days, your conditional appearance is treated as well. Unconditional appearance. And it doesn't mean that your 14 days before the defense will start running from when the conditional appearance became converted to what? Unconditional appearance. In any case, the rules under Order 80 permits extension. So if for whatever reason, the 14 days is too short for you, you can always go to court. You don't even need to wait for the 14 days to elapse. And even if you are a very diligent practitioner and you know how to make money from your cases you're doing, after entering the appearance, 7 or 8 days before the 14 days for filing no defense, you tell the client that you need to go and file the motion because you need to do some more investigation to establish certain facts so that you'll be able to put up a very good defense. You don't need to rush. So let's go and file the motion for the court to give us what? Essentially. Yes. If you are a practitioner and you know how to operate your rules well, you can be making good money from one brief.
The vulnerable.
Not the vulnerable client. It depends upon the agreement. It's for trade. You know, if you practice before, you begin to see client mentality. Some clients they want to see you working before they give you money. So when I use bill partition, certain type of clients, I will actually let them sit in front of me. And I'm doing a lot of work. And you are there, you see me working. So sometimes taking your instructions, typing, going to consult, you are there, you see it. Not that I'm doing it, I'm making it up. No, I mean, if I'm working on your case, you see it. So you sit there for about 5 hours, 6 hours. Then when you are going, how do I say that? Oh, you have to pay some of the money. You not, you know that the delay is working. But if you have also grant by consulting, apart from the grants, or if you have grant by consulting, some of them don't value the work that you're doing. And this is why you are understanding you have been paying money not to know the goal. What are you doing? Isn't it? So those of you excited about because we're getting this from getting money back to the future. Please, pass us to the And that's how you have another class. But let me finish this. Tell your online teacher that we are taking few of his minutes. Which teaches a company law, by the way? Startup Brand. Jude. Yeah, so tell him that me. I said that I should give you a little. Okay, what I could do, will you be having a class here? Good. So you can go. I have some of your people online. So I'll be continuing with them. No. I really wanted us to do. Okay, tomorrow we will use the maybe first hour of the first. Because I know you have to stay a bit. Of course, your evidence lecturer will give you exams, isn't it? Yes. You might not come. Okay. Because I will need the 1 hour for your exam. So, but if it is the case that if you are free, I will come at 3. I will come at 3 and then teach you. Because the learning is more important. So if you have the time, I don't mind. I will come and do more teaching with you. So we do maybe 3 to. You come. So you come tomorrow. It's not a question of ahead. I want you to learn the course. Do very well. Let me know. All right. Okay. All right. So, but still, we finish at the 6:10. That is fair, isn't it? 10 minutes is fair. In any case, you are here. You are not online. Yes. Some of you wondering, when is the lecture starting? So, are you going to project? You have the link. You have the link. Oh, okay. Oh, so just transition from this to that. You can maybe be sitting here. And then we come. All right. Yeah, so please, where we've gotten to is very important. We but please, there's a procedure which will be meeting under Order 11 Rule 18. Later on, when we discuss pleadings, where you bring an application to the court for the court to strike out or dismiss an action for not disclosing any reasonable cause of board action. We are saying this just to alert you that conditional appearance is not for that type of prayer or for that type of request. So I ask you to read the case of the Ghana Muslim Representative Council against Salifu. Ghana Muslim Representative Council against Salifu, 1975 to JLR 246. And the court will remind us that if the writ does not disclose reasonable cause of what? Action, it does not justify condition appearance. You need to enter condition appearance or do whatever, but you don't enter condition appearance because you bring a motion for the court to say that. Because if you are saying that the writ does not disclose reasonable cause of action, you have no problem with the validity of the writ, except that when the content is examined, you don't see any case the person is making what? Against you. That one is different. We are now at the very threshold, at the entry stage. So we are not looking at the writ not disclosing cause of action, reasonable cause of action. But we know the formalities of the writ, remember. So if the formalities are not there, especially the mandatory ones, then they affect what? Validity of the writ. Or if it's not properly said, then the service is not valid. So you want the court to say that the writ has not been said, or the writ to be, or the service to be set aside. That's it. So that is what we use conditional appearance for, and not for matters which are cognizable under Levin Rule 18. So let's keep that in mind. Default of appearance. That is where I wanted us to go. But we'll just introduce it and then continue tomorrow. My 10 minutes is now started. That's what we agreed. It's now 6, isn't it? I will go beyond that. Good. So, default of appearance simply means that a defendant, having been duly served with the writ, fails to enter appearance within how many days? 8 days. Or the prescribed days. Because it's not all the time that it's 8 days, isn't it? Yeah. Sometimes the court might have prescribed the period. So it will be that period. If that period lasts, you haven't entered appearance, then there's a default of what? Appearance. And as we have noted, the writ itself contains a warning. We look at towards the end or the bottom of the writ, you see the warning there that a judgment may be entered against the defendant without further notice in default of what? Appearance. So the writ itself is saying that if you ignore the requirement of entering appearance within 8 days or the prescribed period, you risk having a judgment in default of appearance entered what? Against you. So what is the nature of a judgment or default judgment? A judgment in default of appearance, as it were, or the 10 of CI 47. A judgment in default of appearance may be a final or interlocutory judgment, depending on the nature of the claim. It may be a final or interlocutory judgment. When we say interlocutory means anything from the start of the case until the case has finally been determined. We call that interlocutory. So injunction, for example, when it comes to injunction, let's put at 25. A certain new typology is introduced by the rules, so that we have what we call interim injunction. Interim injunction or limited injunction, as it were, is for a period with the civil law, 10 years. But after that, we have to go for notice, and then the court will try to grant interlocutory injunction. 10 years. But after that, we have to go for notice, and then the court will try to grant interlocutory what? Injunction. 10 years. But after that, we have to go for notice, and then the court will try to grant interlocutory what? Injunction. 10 years. But after that, we have to go for notice, and then the court will try to grant interlocutory what? Injunction. Now, as to whether a judgment in default appearance is a final or interlocutory is very much dependent upon the nature of claim endorsed in the Writ of Summons. The nature of claim endorsed in the Writ of Summons will let us know whether a judgment in default of appearance is a final or interlocutory. And the distinction between final and interlocutory in this context relates to the proof of entitlement. Entitlement. In other words, what must you do to be given a final judgment? What must you do to be given what? Interlocutory judgment. So let's take Order 10, Rule 1. Order 10, Rule 1.
Rule 1. Claim for liquidated. 1. These defendants so and liquidated demand can only, and the defendant fails to file an appearance. Plaintiff may, after the time limited for appearance, apply to enter final judgment against the defendant, for example, not exceeding the main trial rate, and for cost and proceed. And with equal accident against other defendants.
Good. So we are introduced what we call a liquidated demand or liquidated claim. That's where the claim is liquidated. Liquidated means that the amount is ascertained or is known. Maybe you see most of the debt recovery actions are liquidated claims. So where that is the case, you are permitted to get a final judgment. Now, Justice Osel, not my friend, Dr. Justice Osel, his father. So I'm talking about his father of blessed memory. And when he was a high court judge, in the old case of Fofie against Omar, I'm not talking about Fofie and Osuhini. No, there are a lot of those cases. I'm talking about Fofie against Omar. There's a high court decision. I'm not talking about the Supreme Court decision. 1972, 2 JLR 6. There was a very 72, 2 JLR. He made a statement which I quote from the judgment. Quote, just listen, you can go and read it later on. You also be in your notes. Quote, I'm quoting from the judgment. In regard to the point raised that the 5,000 cedis, not the Ghana cedi, because in 1972. So we are talking about the old what? Cedis. The 5,000 cedis claimed as expenses incurred represented a liquidated demand. I think that I sufficiently delivered myself on this matter in my ruling of 28 January 1974, and I have no cause to recant or to look beyond it. This is what I said entirely, I quote. The question that here poses itself for determination is whether the 5,000 cedis can represent a liquidated demand. It has been explained at page 35 of Supreme Court Practice 87 that a liquidated demand is in the nature of a debt. A liquidated demand is what? It's in the nature of a debt. That is a specific sum of money due and payable under or by virtue of a contract. Specific sum of money due and payable under or by virtue of a contract. This amount must either be already ascertained or capable of being ascertained as a mere matter of arithmetic. If the ascertainment of a sum of money, it is further explained, requires investigation beyond mere calculation, even though it be specified or named as a definite figure, then the sum is not a debt or liquidated demand within contemplation of Order 13, Rule 7, under the LN 148. So, which is equivalent of Order 1, the 10, Rule 1 of CI 47. But constitute damages, in which case a defendant is to enter interlocutory judgment for the damages. I think that if the action had been contested, the plaintiffs could not have been entitled to 5,000 cedis claim as a matter of mere arithmetical calculation, but that they will have been obliged to go beyond that, justifying the acceptance of each figure representing the expenses incurred. It is for this reason that I hold that the 5,000 cedis claim represent damages. The final judgment entered in respect of this claim was clearly irregular. So this is a very good, or what we call the locus classicus, in trying to draw the distinction between what a liquidated demand is and then what is not liquidated demand. And the distinction is important because if we're able to say that this is a liquidated demand, it entitles you to get a final judgment. But if it is not a liquidated demand, you need to just get interlocutory judgment. And you have to go to what they call assessment of damages, which we'll be talking about. So the takeaway from Osebure J, as it then was, in forfeit against Puma, is that if that particular sum being claimed is specified, or it can easily be calculated as a matter of arithmetic. Maybe you take your calculator or you do your normal traditional computation. If that can easily be done, then that is liquidated. But if it's not just a matter of arithmetic computation, but maybe you need to be explaining and justify why this should be part of it and that should not be part of it, then it's not liquidated demand. You need to go through proper evidence to prove your entitlement to it. So liquidated demand should just be a matter of either the sum is ascertained or is ascertainable. And then ascertainability is just a matter of arithmetic work, computation, and no more. So I'll leave you with that for tonight, and then we continue tomorrow as we hold yourself in readiness for the D-Day tomorrow. Good night. Yes. Yes. Up to, I mean, of course, no, up to the up to 10 as well, isn't it? Yes, we have to end it for those online.